Welcome back, everyone, to Bankruptcy with Ben. And in today's episode, we have a major new update from Purdue Pharma. To quickly recap, if you recall from our Purdue Pharma series, Purdue Pharma is a major pharmaceutical company that manufactured a painkiller called OxyContin, which contained opioids and fueled the opioid crisis. As a result, they were targeted from thousands and thousands of lawsuits all over the country. They filed for bankruptcy in 2019. They reached a settlement where they would pay all the litigants, including state governments, federal governments, individuals, everyone that had sued them. They would pay them $6 billion. In exchange, the Sackler family, which owned Purdue Pharma, would get a release from liability. In other words, Purdue Pharma would be paying $6 billion through money that was funded by the Sacklers, and the Sacklers would then be immune from any further liability, even though the Sacklers themselves did not file for bankruptcy. It was only the company that had filed for bankruptcy. A lot of the claimants, including the U.S. Trustee's Office, which is the bankruptcy watchdog, they were not happy with that kind of immunity that would have been given to the Sacklers. The case went all the way up to the United States Supreme Court. The Supreme Court, in a very, very contested 5-4 decision, concluded that these kind of third-party releases are not permitted. Again, the third-party release is the Sacklers are the third party because they themselves are not in bankruptcy, and they wanted to be released from all future liability related to their role in the opioid crisis in exchange for contributing this money. The Supreme Court struck it down and said you cannot do that. Case went all the way back down to the bankruptcy court. And now what happened in bankruptcy court is new litigation started where essentially creditors have claimed that the Sackler family essentially funneled $11 billion out of the company over the course of many years for the sole purpose and the specific purpose of putting that money beyond the reach of creditors and then putting Purdue Pharma into bankruptcy. And now they can say Purdue Pharma is a shell of what it once was. So good luck collecting. So now a lot of litigation has commenced in bankruptcy court to try to claw all that money back. And obviously it's enormously complicated to claw back $11 billion, especially given the fact that the Sacklers sent a lot of their money offshore. So now we're back in bankruptcy court. Settlement talks, not surprisingly, settlement talks restarted. Everybody knows that it's in everyone's best interests to try to get this case resolved, because if litigation can go on and on and on and on for many years, there's going to be no end to it. Even Lehman Brothers, which filed for bankruptcy in 2008, there's still activity going on from that bankruptcy case. So you can imagine $11 billion of claims or $11 billion of assets. The actual claims are into the trillions, but $11 billion of assets to try to claw that back can go on just endlessly. So the parties all went to mediation originally, which is how that settlement came up. Now they're saying, okay, judge, there's litigation, but let's take another crack at it. Now that we know we have some guidance from the Supreme Court, what's going to work, what's not going to work, let's see if we can take a second crack at it. The important thing is that while the litigation is ongoing, there was a temporary freeze. While the mediation was ongoing, the bankruptcy judge, put a temporary freeze on the litigation that had been taking place within bankruptcy court and put a freeze on litigation outside of bankruptcy court. So outside of bankruptcy court, the litigation was to put liability on Purdue Pharma and the Sacklers for their role in the opioid crisis. In bankruptcy, the litigation was to try to claw all those assets back. So the judge put a temporary freeze on litigation in order for the mediation to try to work. The judge, though, did not give the Sacklers, did not give Purdue Pharma, did not give the various parties that are litigating endless amounts of time to reach a settlement. There was a definitive timeline. The judge is trying to keep it on a short leash to gently encourage the parties that they need to settle. So what happened is that initial deadline was now starting to come close. So there was a court hearing recently, and at that hearing, as we're going to see, there's a whole article written up in MSN about it. The mediator in that case is really, really trying to get the judge to give him a little bit more breathing room and try to make this settlement work. So let's take a look. Okay, so 1 second. All right, so we have here an article from MSN. Purdue Pharma nears bankruptcy deal with Sacklers, mediator says. Purdue Pharma is close to new bankruptcy settlement with its owners. And who are the owners? Members of the wealthy Sackler family. And then on the flip side, you have the creditors. Who are the creditors? You have state and local governments that have filed lawsuits that say the painkiller OxyContin spurred the opioid addiction crisis in the U.S. But the mediator says we're near a settlement. Mediator Shelley Chapman said at a court hearing in White Plains, New York, that Purdue has made real progress in recent days on a comprehensive deal that would resolve the lawsuits, adding that she would soon file a written report on the results of mediation. So one thing, as we'll see in a minute, is the mediator cannot say what the substance of the mediation was because that's confidential. So the judge, in a certain sense, is taking the mediator's word for it when the mediator says there's been progress. The parties are getting closer and closer by the day, and the remaining issues, in our view, are resolvable, Chapman said. So the mediator is trying to paint a picture to the judge that says, Judge, there's a lot going on here. We can't discuss the specifics, but we think we're getting close. And that happens a lot in mediation, and parties are talking and talking, and the judge is left in the dark because that's the nature of it, is that mediation talks are confidential. The judge cannot know what is going on. But when a party is appointed, or I'm sorry, not a party, when an individual is appointed as a mediator by the courts, there's a certain amount of reputation that they have. And so them giving the court their word, it means a lot. And the judge is going to rely on that to an extent. Chapman urged U.S. bankruptcy judge Sean Lane to extend a freeze on opioid lawsuits against the Sacklers until December 2nd. So that's important. It's not going to go on forever. And saying that if you allow the lawsuits to resume, it would undermine settlement talks and deplete resources that should be reserved for paying opioid creditors. What does she mean by deplete resources? Meaning you're going to spend money on litigation. So all the lawyers are going to have to get paid for their work on litigation. So the more money that goes to the lawyers, the less money that's going to go to the creditors. So let's instead try to pool our money towards actually settling this case. And what does the mediator say? You cannot make war and peace at the same time, Chapman said. In order for the mediation to succeed, we need the full undistracted attention of all the parties. So you can't be on the one hand having talks and saying, let's get this resolved, but on the other hand, it's trying to shoot them dead, right? You can't, if we're going to be at peace, we're going to try to resolve something and negotiate, then we're going to have, a quote unquote ceasefire. Purdue was sent back to the drawing board after a landmark Supreme Court ruling upended its previous bankruptcy plan, which would have granted sweeping legal protections to the Sacklers, meaning they would have been released from liability in exchange for up to $6 billion that would have been spent addressing the harms caused by the opioid epidemic in the U.S. Chapman did not discuss any of the terms of the deals because she can't. Attorneys representing state and local governments also declined to address the terms under discussion. Again, they're not allowed to. Mediation is a confidential process. And saying at the same time, they're optimistic that a new deal could be reached before December 2nd, the date when the current litigation stay is scheduled to expire. And there's another thing going on, which is that if you want mediation to have a chance of success, you have to put a good face to the public. You have to say, yeah, we think it's going in the right direction. You can't start throwing another party under the bus, say, oh, well, the other party, this, that, and other thing, and why are they doing that? In private, you can have all the talks with the mediator you want. You can certainly feel free to voice all your displeasure with the other side to the mediator. That's the point of the mediator. But in public, you got to, make nice in public and say, oh yeah, everything is going real well. The Supreme Court ruled on June 27th that Purdue Pharma's bankruptcy settlement cannot shield the Sacklers who did not file for bankruptcy themselves. Again, like we said, the Sacklers are not in bankruptcy. The company's in bankruptcy. And then again, the bankruptcy was filed in 2019. And since then, the opioid lawsuits have been on hold. If mediation fails, a court-appointed committee representing Purdue's creditors has been allowed to sue the Sacklers over claims that they drained over $11 billion from the company, and their conduct made Purdue liable for other lawsuits. So that's the key point, is if we don't settle, we're going to try to claw back $11 billion. So that's the article. Let's take a quick peek at the actual mediation order. It's pretty short. We're just going to go over some of the key points before we wrap things up here. So here we go. Third amended order appointing the Honorable Shelley S.C. Chapman, retired, and Eric D. Green as co-mediators and establishing the terms and conditions of mediation. So right away, remember I was saying earlier that what the mediator says carries a certain amount of gravitas, a certain amount of weight. One of the big reasons that what this mediator says means something is because this mediator is a retired bankruptcy judge herself. So she was a colleague of the current bankruptcy judge. They know each other. Having that kind of gravitas as a retired bankruptcy judge, the court is going to say, okay, you're not just any random party. You're a bankruptcy judge. I know I can trust you. So the court, and this order is dated November 1st. So October 30th, I believe, was the hearing when the Judge Chapman said, Judge, let's give this a shot. And now the next day, 2 days later, November 1st, the court issues the order, essentially approving the mediation and extending a limited stay on litigation. Effective immediately, the court authorizes and appoints the Honorable Shelley Chapman and Eric D. Green to serve as co-mediators in these Chapter 11 cases. Now, Mr. Green, the court does give his credentials. Unfortunately, just the nature of it is when you're paired with a former bankruptcy judge, you're going to be sort of quote unquote second fiddle. So everyone knows it's Judge Chapman who's the public face of this, and it's not to diminish in any way the work done by Mr. Green. He himself is obviously an enormously credentialed mediator as well, but just, the nature of it, there's a judge on one side, you're always going to be second fiddle. Co-mediators are authorized to determine the procedures to govern the mediation in their sole discretion, meaning the court's not going to set how the mediation is going to go. The mediators have discretion. For the avoidance of doubt, the co-mediators are authorized to communicate in their sole discretion on a confidential basis with the U.S. Department of Justice regarding the mediation and the mediation topic, with or without the mediation party's participation or prior consent, without any further order of this court, provided, however, that the co-mediators shall be limited in what they can share with the Department of Justice in the same manner in which they are limited with any other mediation party. The Department of Justice shall be entitled, without further order of the court, to participate in appropriate mediation sessions as an observer as determined by the co-mediators. And why this is very important, what this is saying is that the government, the federal government, the United States Department of Justice, is going to have some kind of role in the mediation. If you recall, the United States Trustee's Office, which is the bankruptcy watchdog and a division of the Department of Justice, they're the ones in the last go-around that really derailed the settlement. They're the ones that took it all the way up to the Supreme Court, and said to the Supreme Court that these third-party releases are not permitted. So it's very, very important for everybody involved to have the government on board, because you do not want another repeat. You do not want it to just simply, go where they have agreement with everyone except the government, and the government comes in and says, no, we don't like this for whatever reason. So they want the government's participation to an extent. Obviously, there's still confidentiality terms that they have to abide by, so it's not limitless, but to a large extent, they're going to be a part of the process. But here's an important point. The mediation shall terminate on December 2nd, 2024 at 11:59 p.m. So it's a very, very short time frame. It's basically 1 month from the date of this order. So the court is saying it's not going on endlessly. It's either going to go or it's not go. There's a lot of people here who want their day in court. And if it doesn't settle, then they're going to get their day in court. And, the pieces fall where the pieces fall. And that doesn't mean that parties can't settle afterwards. You can always reach a settlement. It just means that this prevailing mediation that the court's going to authorize, and also putting all the other litigation on hold, it's going to end on December 2nd. So they have until December 2nd to come up with an agreement. All right, let's see if there's any other kind of points we want to go through. Again, this is very important, as we were discussing. All communications made by and all submissions prepared by a mediation party in connection with the mediation shall remain confidential, shall not be made available to the public. So again, that's one of the key points of a mediation, right? You want things to remain confidential, because if one side starts talking to the press and talking to the public and saying, oh, well, we discussed that and that, that's going to kill the whole deal. Everyone is kind of talking for the purposes of confidentiality. It's almost like, when you go to your doctor, right? Your doctor is bound by HIPAA laws. Your doctor cannot disclose things to the public. The reason is to facilitate open and honest communication. And you want to be able to tell your doctor whatever you need to tell them, and not be worried that this is somehow going to come back down the line to harm you in any way. So it's the same thing with this mediation. You want to encourage open and honest communication, and not say something which can somehow be used against you at some other point down the line. So it needs to all be confidential. However, there are limits on that confidentiality. Nothing in the order limits the ability of any mediation party to speak publicly, whether through court pleadings, court statements, or otherwise, regarding issues in these cases, provided that doing so does not disclose confidential mediation exchanges. So what that means is they can discuss broad outline of the legal issues involved. They just can't say, oh, well, Mortimer Sackler, Richard Sackler, or John Doe, or an attorney from Davis and Wolk and Purdue, which is the law firm for Purdue, that they said, oh, we could do X, Y, Z, right? So you can say broadly what the issues are about. You just can't say specifics. Also very important is it does not limit their ability to comment on the opioid crisis and those involved in it, these debtors or these cases, provided that doing so does not independently of this order violate the protective order. The protective order meaning the fact that everything is confidential, right? So they can give general comments about the opioid crisis, say, it's caused a lot of destruction. There's a lot of education that needs to be done to help people who were victims of the opioid crisis, to help just general public education about the issues, public health discussions. So you can comment broadly. It's not kind of meant as a restraint on their First Amendment rights to speak. It's just whatever is said in mediation as kind of a confidential statement that has to remain confidential. Let's see if there's anything else. That's the gist of it. Entered November 1st, 2024. The Honorable Sean Lane, United States Bankruptcy Judge. So that's where we're at. Let's keep updated. We'll see where this goes. We'll see if by December 2nd, there is a settlement in place. If I had to make a prediction, I predict that this case will settle. That December 2nd is not necessarily a drop dead date. The court said December 2nd, but if a retired judge comes back and says, okay, Your Honor, there's been a lot of issues. There's only one little issue. There's two issues. We really think if we get another month or two, we could work it out. most likely the judge will extend it. The judge wants to keep things on a short leash and wants to make sure that parties kind of feel the pressure of the deadlines and going to court and having to keep the judge informed of what's going on. But that doesn't mean that the judge is going to say, oh, you didn't meet it by December 2nd. No, I'm not giving you a second more to discuss the case. Done. We're going back to litigation. I'm going to kill it. The judge wants to monitor it, make sure things, their feet are held to the fire from all sides, and that things actually get done. I think a settlement is going to happen. We'll have to see what the terms look like. It could very well be something along the lines of a consensual release, meaning this Supreme Court did not say that consensual releases are prohibited. They just said you cannot force a party to give a release against their will. So you might have a situation where everyone's agreeing that the Sacklers can get a release. So we'll see. A retired bankruptcy judge is obviously going to be very, very creative in how to structure this. So stay tuned. That's it for now. If you enjoyed this video, remember to comment, like, and subscribe, and we'll see you all in the next one.